morning, everybody. Welcome to today's webinar, Duty to Manage, Who Holds the Responsibility? I'm Victoria. I'm the Events Manager here at UKATA, and I'm going to be supporting with this webinar today. I'll be supporting with a question and answer session at the end. Just before we begin, a little bit of housekeeping. This session will be recorded, and at the end we will send you a copy of the recording alongside the presentation. If you've got any questions throughout, please use the Q&A box and we'll answer the questions at the end. Avoid the chat box, please, because those can sometimes get missed. If we're unable to answer your question during the session, well, at the end of the session, then Graham will answer and respond to you following this webinar today. If you experience any technical issues, just try logging out and logging back in again, as simple as that, and you should be able to get back in. You can use the chat box in the event of any issues regarding technical difficulties, but as I say, that one can be missed sometimes. If we're all ready to go, I'd like to make a start and introduce our speaker today, and thank you for supporting with this, Graham. Graham O'Mahony, the Chair of UKATA. I'll hand over to you if that's okay.
That's great. Thanks,
Thank
Victoria.
you very much.
Good morning, everyone. Thank you for attending this webinar, and thank you, Victoria. For those who don't know me, I'm the current chair of the association and have been for the past 8 years, and a board director for over 12 years. I work closely with Craig, the COO, on the strategic approach for the association, and my background is from construction, from the construction industry, from a plumber to a building surveyor, to an asbestos surveyor, to a training provider, and obviously consultant. During my time at university, the duty to manage was being consulted on, and my dissertation, 10,000 words I might add, was on the impact of the duty to manage asbestos, and I actually got quite a good mark in that. That was over 25 years ago. So for the last 25 years, I have been dealing with asbestos matters, advising clients on their responsibilities, in particular with regard to the duty to manage. So I'm here today to give you an insight into that role, the duty holder, and we'll touch on the duty to manage, but this is not a webinar about the duty to manage. It's more about that responsibility, who holds that responsibility. I've a few slides to share, well, quite a few actually, but I'll whisk through those very quickly. So it'll be about 30 minutes, leaving some time for questions that you may have afterwards. As Victoria mentioned earlier, as with all webinars that UKATA have been putting together, if there are too many questions and we don't get time to answer them all, we'll compile these and then publish the answers, and then we can do a follow-up if needs be. I've got a few ideas maybe for some future webinars, should we need to. Right, just bear with me. I've just got to try and share my screen. I'm not a great fan of Teams. Right, I'm assuming you can all see that, hopefully. Victoria, can you see that, just to confirm? No, she's not there. Right, okay, never mind. Right, okay, so that's me. That's as the current chair, as I've just mentioned. So if we have a look at what we'll be looking at today, so on the screen you can see my agenda. It's a very light agenda. It's nothing too heavy. So the first thing we're going to be looking at is what is a duty holder. We hear this role quite a lot, and it is mentioned quite a lot, obviously, for asbestos and other pieces of legislation. What does it actually mean? So we need to have a look at that. What does the law say? We're all probably familiar with the asbestos laws that we have in this country, so I'll take a delve into that briefly. We can then look at who the duty holder is for asbestos, and in this section I'll look at a range of different property types to hopefully make it easier to understand. And then finally, the appointed person. Now, some of you may not be familiar with this title or this role. It may not be a necessary role, but in many scenarios, it is becoming a very important role. I will explain that a little bit later. So, as I've mentioned earlier, we hear this term duty holder quite a lot. What does it actually mean? So what I want to do, I want to really break this down and be very simple about this. And I want to break down the word duty holder as one word, but break it down into the two words that we have. So the first word we need to look at is the word duty. So we can see it's a noun, but what does the dictionary actually say about this word duty? It goes on to say a task or action that a person is bound to perform for moral or legal reasons. So first thing that jumps out there is legal reasons. As we're aware, there are legal requirements for the management of asbestos. The other key word there is person. So if we was to just break that word duty down, what we would end up with, to simplify it, is we need a person to undertake a task for legal reasons, which is simple enough. And I think that's fair to say that cuts out that first word. If we then continue and dissect the term even further, we get the word holder. Now, some of you are thinking, and that's an easy one. It's an example of a device or an implement for holding something like a candlestick or a mobile phone holder. So trying to put this definition then into context where we're referring to legislation, the law and legislation, it goes on to say we have a person such as an owner who has possession or control of something. So again, let's break the key words down. So an owner, so when we talk about asbestos, this could be the person who owns the building and the asbestos within the building. Also, another important word or phrase, control of something. So an owner who has control. So if we now put our two words back together, what we end up with is a person who, for legal reasons, needs to undertake a task if they are the owner and in control of something. So hopefully that will now start to give you a bit of a way forward in understanding the role or the responsibilities of a duty holder. Now, obviously, when we refer to legislation, excuse me, certainly in particular with the Control of Asbestos Regulations, the duty holder is defined or written as one word, as you can see on the screen there. It's a one word definition. So I thought I'd do a little bit of research into this, and I thought, well, let's have a look and see what the true definition using maybe the Oxford English Dictionary of the duty holder, because I've just broken down duty and holder, smash them together. If you ever watch that program on BBC Two, Answer Smash, or whatever it's called, that's pretty much what I've done. So when we look at the term duty holder using the internet, there's no results. There's no results for a duty holder as written down. So although we see it documented as one word, duty holder, it doesn't exist. It's not in the Oxford English Dictionary. So we'll go back to my previous definition where we broke it down from duty and holder, a person who for legal reasons needs to undertake a task if they are the owner and in control of something. But hang on, we've got alternative sources now. And many of you are probably familiar with AI. So I thought, right, let's look at this ChatGPT and have a look at the AI definition of duty holder. And lo and behold, something came up. So I'll read from screen. A duty holder is an individual or organisation, so we've touched on those already, with legal responsibility, again, which we already looked at, breaking down duty and holder, for insurance compliance with specific regulations. Specific regulations we're talking about today is the Control of Asbestos Regulations 2012, and it goes on to say particularly in health, safety and construction. It goes on to say duty holders are accountable for identifying risks. Okay, let's put this into practice then and make it a bit more practical with regards to asbestos. Identifying risks. Well, we know asbestos is a risk, so duty holders are accountable for identifying asbestos. Implementing safety measures. So safety measures, implementing control measures, shall we say, by isolating areas, by making repairs, etc. And ensuring compliance with the relevant laws, which we know are the Control of Asbestos Regulations as it currently stands. It goes on to say their obligations vary based on the industry and jurisdiction. Jurisdiction is quite an important part, especially when we start to look at who the actual duty holder is. So it's not dissimilar, the AI definition, as to my definition or our definition earlier, a person who for legal reasons needs to undertake a task if they are the owner and in control of something. So there we have it. That's the true definition of a duty holder. Now we've got a better understanding of that. We also come across it in other legislation. It's just more for information. This one, anybody who deals with costs on a regular basis does occasionally mention duty holder. Anybody in this webinar who is dealing with Legionella and assessments, they make reference to the duty holder. Even electricians who hold memberships with trade bodies, they are required to have duty holders as part of that membership and accreditation. Equally, the gas industry also makes reference to the duty holder. So you can see it's used in quite a lot of other sectors, not just asbestos. But of course, what we're here to talk about, I'm here to talk about, obviously, is the asbestos sector. So now some of you are wondering why I'm delivering this webinar. And if you know the history behind asbestos management, you know that this is not new. This is not something that has just happened in the UK, and we're now starting to have to implement the duty to manage and have duty holders. It's been around for many, many years, but we still find various reasons that people are confused or that they don't want to be a duty holder. But I'll come back to that a little bit later. So first mentioned in the middle of the screen there, in 1998, following on from reports in the mid-90s regarding the increase in asbestos-related diseases in the trade and construction industry, construction workers in particular. However, those of you that are as old as me and remember this, when this first was mentioned in 1998, duty holder wasn't mentioned. It never mentioned a duty holder. It referred to the employer, and the employer would be responsible. Now, this caused a lot of concern for employers, who only used the building to work in. They arrived at 9 o'clock, left at 5 o'clock, weren't responsible for any part of the fabric of the building. So that slowed the implementation of this management of asbestos down. Therefore, it was further consulted in the year 2000, but with the reference to the employer being dropped and replaced with the duty holder. So that's where we first saw the duty holder mentioned in the consultation in the year 2000. We're now in 2025, so it's been around for 25 years. The duty to manage and the title duty holder were then introduced under the Control of Asbestos at Work Regulations 2002. And of course, due to the work involved, there was a delay in implementing or becoming enforceable, such as duty holders required to have surveys, inspections, registers, and put management plans together. So the HSE provided this 18-month lead-in period before it was enforceable. So from May 2004, it became enforceable in UK legislation. So for many years, we have had duty holders, or we thought that duty holders were in place, doing what they need to do. And here we are today, 25 years on, still discussing the duty holder. It was further revised in 2012 when the ACOP L143 and L127 were merged and consolidated into one document. Many of you would know this as L143 second edition, you know, the purple one, the one that most of us will refer to on a regular basis. But just as an added point here, I've mentioned a document there which some of you may never have seen or never be familiar with. It's a document called L127. It was entitled The Management of Asbestos in Non-Domestic Premises. So back in 2006, we actually had two ACOPs, 127 and 143. One ACOP was aimed at the working with asbestos, and the other ACOP was aimed at purely Regulation 4, the duty to manage, shall we say. But of course, when they merged them together, obviously some elements were lost. Now, I remember that document quite well, and I thought it was a well-written document. Some elements were removed. You can't download it now. You can't, well, you might be able to get hold of a copy from somewhere. You certainly can't refer to it as an approved code of practice. But just as a piece of advice, if you can get hold of a copy of it, it does set out the steps the duty holder needs to take quite clear. I think there's 5 steps in there, quite clearly steps out how or what a duty holder needs to do and how to manage the asbestos. I found an easier read, believe it or not, than the current ACOP L143, but that is just purely my opinion. That's not UKATA's opinion, that's just my personal opinion. Now, people often ask me, are we managing asbestos correctly in the UK? And I can't answer that question without all the facts. But from my experience, there are many organisations that are not managing asbestos in the spirit of the regulations. Despite it being enforceable for so many years, they merely arrange for a survey, they hand it to the contractor before work begins, no register, no action plan, no communication plan, just a survey which could be out of date as quickly as it's actually been produced. So now we have a better understanding of the history. It has been legislated for 23 years. And it's been enforceable for 21 years. So as I mentioned, this is not new. It has been around for many, many years. So now some of you are probably asking that question, why am I doing this today? Why am I talking about the responsibilities of the duty holder? Well, as I've said, it's been around for 20 years. Surely everybody should be aware of their responsibilities and what they have to do. So you would think. But in my experience, when I deliver asbestos management courses and ask the audience who here is the duty holder, the hands remain down. Ask the question who wants to be the duty holder, the hands are on the floor. The role of the duty holder for asbestos must have the slopiest shoulders. No one wants it. But why? It's just another job. It needs to be done. And remember, there are many hazards in the workplace. Asbestos is just one of them. So I've got a few ideas here why people don't want the job. Confusion. I don't understand. Now, if you actually are a duty holder and you was to read L143, Regulation 4, all the paragraphs, you would understand pretty much what needs to be done. But it's not written in a layperson's terms in that what do they have to do. Sometimes it can be a little bit confusing. Nobody wants the job. It's too difficult. You read the text and you think, right, this is what I need to do, but that's very, very difficult. I've got other things I need to do as part of an owner of a business, shall we say. The bottom one is probably the most important one that people recognise with, what if I get it wrong? Will I be prosecuted? I've heard stories that people believe that if they get an asbestos management issue incorrect or wrong and there's a potential exposure, the enforcement authorities come down on like a ton of bricks and they're going to go to prison. I can't say for everything, but I can't understand that being the case. The end of the day, as long as you're doing it correctly, seem to be doing it correctly, things do go wrong. We all understand that. But obviously, if you follow the steps and you understand your responsibilities, all those things of confusion, too difficult, prosecution will all go out the window. It's not difficult to manage asbestos. It's just having the time and the resources. However, somebody is responsible. So the regulations mentioned earlier, the Control of Asbestos Regulations 2012 or CAR 2012, relates to the duty to manage, Regulation 4 in particular, and this is where we see the definitive definition of the duty holder, which states the person, mentioned that earlier, or organisation, mentioned that earlier in my dissection of duty holder, that has the main responsibility for maintenance or repair of non-domestic premises. So I've underlined a couple of keywords there, person or organisation. So we're looking for somebody or some entity that is going to be responsible and act as that duty holder. The other keyword is the level of responsibility for maintenance. So personnel involved in maintenance or overall responsible for maintenance have obviously got clear responsibilities there. And the other key one there is non-domestic. Okay, we'll come to the last paragraph shortly. So let's now revisit what happened in the mid-1990s with the report on the increase of trades such as plumbers, carpenters, electricians developing asbestos-related diseases. These are considered the most at risk from exposure during their work. This is why we have a duty to manage, and we have that title, the duty holder. However, we also need to consider other users of the building as well, such as workers, employees, staff and visitors. So although this definition, the person with main responsibility for maintenance, that person who's responsible for maintenance might not be responsible for the day-to-day operations that go on inside that building, for employees, for visitors, etc., etc. So somebody else needs to probably help out in that sense, but we'll come back to that a little bit later. But there's other legislation there that the Health and Safety at Work Act would obviously play as part. The last paragraph on the screen, the duty to manage does not apply to domestic premises, such as someone's home. There is other legislation that covers this sector, but we can save that for another day, but I will touch on that a little bit later. So using the definitions under car, the duty holder may be on screen, the owner, the landlord of the premises, the person or organisation with responsibility for maintenance or repair, as we've just touched on. May also be the tenant. That's an interesting one, where obviously the tenant could become a duty holder, and in some circumstances it may be a shared responsibility. Now, I'll start this off very simply, and I'm going to look at a very simple arrangement to highlight who the duty holder is. So an example on screen there, let's take it's my office. Okay, I own the building, I am the employer, and I'm responsible for everything to do with that business and of course that premises. So as I own it, I occupy it, it's a workplace premises, so it's non-domestic. Therefore, I'm responsible for the maintenance and the repair of those premises. Simple answer is I become the duty holder. It's not difficult at all. Now, that's a very easy one because you own it, you're responsible for it, and it's a non-domestic premises. However, what happens if we find a situation where we have an owner who rents out the workplace premises, say for example to a tenant? The tenant is under what's called a full repair and lease, i.e. the tenant is responsible for all maintenance and repairs within the premises. So although they don't own it, they are in control of it, mentioned that word earlier, but they're not the owner, but they are responsible for the maintenance and repair within this premises. Therefore, the tenant would be the duty holder. Now, in this situation, there might be an alternative. It might be, and a lot of tenancies do work like this, that the tenant is responsible for the internal fabric of the building, but the landlord is responsible for the external fabric of the building. So therefore, who is the duty holder in this situation? Well, in that case, the duty holder would be the tenant for the internal, but the landlord for the external. But we'll see later on a slide, they will have to work together to ensure the spirit of the duty to manage is in place. And remember what that spirit is to prevent people's exposure to asbestos, certainly more importantly, when undertaking maintenance and repair works or construction work, shall we say. So now we can start to touch on tenancy agreements. And if you have arrangements where you have tenants and tenancy agreements, sometimes it might be important to maybe consult and determine who the duty holder is within these tenancy agreements. I would tread carefully with this one though, because as many landlords, when they let their properties, they have standard clauses in their agreements. And lawyers and solicitors, they write these in all the time. And you can ask a solicitor, a lawyer, why do you write this in? They say it's just an easy phrase that we put in. And sometimes the tenants might not be aware that they could actually be defined as a duty holder under the tenancy agreement. But obviously, we've got to consider the level of control and maintenance, obviously, within that agreement. And the common statement I'm referring to, and those of you who are involved in legal or tenancy agreements and landlords, etc., it's a very common phrase that we use or is heard, and it states the tenant will be responsible for all statutory obligations. Now, asbestos management is a statutory obligation. Tenants might find themselves in the situation that they have the responsibility but know nothing or very little about asbestos management. But then there is the cost to consider in managing that asbestos. Now, I would like to imagine that any tenant, certainly in the last 10 years, taking over a property, the landlord will provide maybe information as location and whereabouts of asbestos. Therefore, the tenant can then manage that. Where they don't provide this information, the tenant would then be responsible for sourcing that information. Therefore, there's a cost in identifying it, surveys, putting registers together, developing a management plan, etc., etc., etc. So tenants do need to be very mindful rather than just quickly sign their tenancy agreement. They do need to think about what does that tenancy agreement actually say. Now, managing agents. We may have some managing agents and landlords in attendance today, and many landlords who engage managing agents to look after their buildings will expect the managing agent to take on the role of the duty holder because they're managing the property, which is fine in principle, of which they would be paid to manage the asbestos. However, the legal obligation to comply cannot be passed to the managing agent. In essence, a managing agent would be considered to be an appointed person, which we touched on earlier in my introduction, but we'll look at that a little bit later. A similar scenario would be had for caretakers and site managers. The legal responsibility cannot be held by them. So this would revert back to the person with the main responsibility for the maintenance of the building, such as the landlord or the owner. So if we've got any caretakers or site managers, you're never going to be the duty holder, but you might be assisting the duty holder. Same with managing agents, might be assisting the duty holder to ensure compliance. So let's look at some other property sectors that we might find ourselves dealing with. So on the left there, it says in public buildings, who the duty holder is dependent on who is responsible for maintenance. Now, with regards to this one, it's probably quite an easy one. For example, most hospitals, local authority buildings, the duty holder will be the employer. Therefore, it will tend to go to the CEO or the COO, the managing director. It generally goes up the top of the chain to the most senior person within an organisation. But we'll come back to that shortly with regard to that senior person as to whether they know what they are to do to manage the asbestos. Now, this is where for many years duty holders for schools was very, very confusing. And as mentioned earlier, nobody wanted the job. When the HSE revised the 2012 regulations, there was a consultation and there was an opportunity for more information about who the duty holder was in a school situation. Now, due to the different types of schools, they've added further guidance on this as to who the duty holder is likely to be. But prior to 2012, it was very subjective, and we had to go back to a base model of looking at who the person or organisation was and if they were responsible for that maintenance. So we've got a few examples here to look at various schools. So a local authority school, for example, the local authority is responsible for the school and its maintenance. Therefore, the local authority would be the employer and, of course, the duty holder. So looking at the key personnel in this case, that would be the chief executive, who's likely to be the duty holder, but may delegate that work to, say, an appointed person. So again, we're bringing this appointed person into play here quite a bit. For voluntary aided and foundation schools, the Board of Governors will be responsible for this, and the duty holder may be an individual. They may choose an individual within that board, such as the Chair of Governors, who takes on that responsibility. But again, because they're not involved in it on a day-to-day basis, they may delegate that to someone else to undertake those tasks on their behalf. Academy and free schools, very similar in essence. So we've got a trust, we've got the Board of Trustees. They will generally be responsible, and like the foundation school, an individual might choose to be that sole person that takes on that responsibility to ensure obviously compliance is met, but again may outsource that work to an appointed person. For independent and fee paying schools, it could be a number of people. It could be the proprietor, the governors, the trustees, depending on the arrangements that they have in place, but ultimately they would be responsible for the maintenance, so may well hold the budget for maintenance and therefore hold that responsibility. So it's trying to sort of track down who is ultimately responsible, but I've got something later I'll share with you. And finally, where schools buy back services for maintenance from local authorities, which is quite common, the duty to manage will be shared between the two parties. So it would be shared between the independent school and, of course, the local authority if they are doing certain types of work activities. Ultimately, ideally, we're looking for one duty holder in most cases, but it doesn't always happen. So hopefully, looking at the various non-domestic building scenarios in this presentation, you can now start to see where the responsibility lies and who holds that responsibility. However, please understand that every site has a different setup, and I can't be prescriptive to cover every scenario on a webinar like this. I just something to share later, as I mentioned, to help you assist in trying to track back who the duty holder could be or is. But we'll look at that a little bit more detail, later. Now, We mentioned earlier in the slide which mentioned the control of asbestos regulations, and we mentioned about non-domestic premises, but it doesn't apply to domestic premises. So we've been looking at non-domestic premises, but what about the 30 million domestic buildings that we have in the UK? Some owner occupiers, most of them owner occupiers. About 4 million of these are social housing properties, and that's not including private sector landlords. Many of these domestic properties will still have asbestos within the property. Do we know where it is? Probably not. It's a huge task. So why doesn't the domestic sector fall under the duty to manage? So just a quick bit of information why the domestic properties don't. When the regulation was first introduced, there was a requirement to re-inspect the ACMs found in the building annually, every year. This has now changed to a risk-based approach. Yes, I've said it, they don't need to be inspected every 12 months, although a lot of people still do them every 12 months, but it's a risk-based approach. But imagine local authorities and private landlords having to re-inspect the asbestos in their domestic stock annually. The cost, the time, and the issues with access would make it impossible. There is a requirement for gas inspections annually, and these are difficult to achieve to 100%. So could you imagine a tenant allowing access to look at their ceiling annually? It wouldn't be cost effective, or probably not achievable anyway. It's hard enough to get the gas done, let alone the textured coating ceilings. However, there are other requirements under CAR, and I could refer you on to Regulation 5 before works are undertaken in domestic properties, and other legislation that puts an onus on landlords to identify asbestos in domestic properties, i.e. where somebody lives. That said, the common areas, common parts, they do fall under the requirement to manage asbestos. So this would include communal areas, blocks of flats, but not the individual flats themselves, and areas within houses of multiple occupation. Not the shared facilities like kitchens and bathrooms, but more common areas like the through routes, the stairs and the corridors, etc. In these cases, the landlord would be the duty holder. So for housing associations, local authorities, the landlord, the owner of the property, would be the duty holder regarding the common parts. Now, again, I touched on this previously. Any person who has information on the premises or in control of the premises has an obligation to assist the duty holder where necessary. So this could fit in with the landlord looking after the external, tenant looking after the internal. They must cooperate. It doesn't extend to paying for the costs though, and I've got a good example of this where a landlord is the duty holder, but the tenant is in occupation all day, every day. Have control of the premises. They should assist the duty holder, ensure that asbestos isn't disturbed. They've got an obligation there. Report any disturbance to the duty holder, the landlord, and the information on the location is shared with maintenance contractors who are visiting the property. But they won't be responsible for paying for the surveys or undertaking the re-inspections. So again, this comes back down to referring to our tenancy agreements and where those tenancy agreements come into play and how it's documented in those tenancy agreements. Now, as I mentioned, I've been involved with asbestos management for quite some time now, and I regularly get involved with some legal cases. So a case study I was involved in a few years ago. So it's quite an interesting one, this one. And my commission was to determine who the duty holder was. There was a big argument who the duty holder was. So a tenant rented a premises from a landlord in 2018. Under the terms of the tenancy, the tenant was responsible for cleaning / maintenance of the premises. So they've got an obligation there as a duty holder. However, the explicit term used in the lease stated the tenant is responsible for all statutory obligations. So we looked at that earlier. Duty to manage, maybe. Fire, Legionella, all the other statutory obligations that would come from that. The landlord undertook the survey in 2004 and 2014, held a register, re-inspected annually, and held this information to share, but requested any works would require approval from the landlord. So the landlord basically had total control of all maintenance works that were undertaken. They checked the RAMs, making sure obviously they could check the survey, the registers before allowing that work to be undertaken. So in that scenario, who is the duty holder? Because the tenant is responsible for statutory obligations, but the landlord is doing all the work of a duty holder. So what happened? The tenant undertook some cleaning, approved by the landlord. They were pressure washing and disturbed some asbestos, creating a lot of contamination with a damages claim in the region of £250,000. The damages claim was in relation to relocation, cleaning up, plant equipment that had been contaminated. The argument from the landlord was that the tenant was responsible and was the duty holder under the agreement. The tenant disagreed, as you would imagine. The survey, the 2014 survey, showed that there was asbestos in that area where the cleaning was undertaken prior to the cleaning being undertaken. So how did it happen? Whereas you've got the landlord who's had a survey in 2004, survey in 2014, shows their asbestos. The landlord's in control of all of that work. They must check their assessments, the risk assessments, their method statements, and of course they would check back against the register to see if there was asbestos in the area. No one identified it. The 2014 survey showed that there was asbestos. However, when the survey was provided to the tenant to assess the work, the survey from 2004 was provided and it did not show any asbestos. Now, that is a completely another webinar to talk about surveys that were done 20 years ago compared to surveys that were done 10 and 5 years ago, and the difference in quality of those surveys. But as I said, let's save that for another day. Therefore, the landlord did not pass on the correct information, hence the damage. The question still stands. Who is the duty holder? Under the tenancy agreement, the tenant would be the duty holder as they're responsible for all statutory obligations. So if we argue the tenancy agreement, that would be correct. However, all that was required to manage the asbestos was being undertaken by the landlord, who shared all this with the tenant, or so they thought. So the landlord was acting as the duty holder, but didn't want the title. Again, come back to this. It's not my responsibility. I'll do it, but I don't want the legal responsibility. The landlord was acting as a duty holder, doing all the work, so they were by default the duty holder. However, the landlord did not share the correct information at the time and therefore would be liable for a failure to provide the accurate information. So again, failure to cooperate. So we looked at cooperation earlier. The determination of the duty holder was never finalised, never got to the end of it. The £250,000 claim, I think it was just settled. They went half and half. They both admitted liability, but you can imagine after that they would have then made it very explicit who the duty holder was. However, obviously any of those definitions or certainly determinations of who the duty holder is could be challenged legally, especially with regard to the tenancy agreement and of course the duty holder acting as, sorry, the landlord acting as the duty holder. So we're at a place better idea of who the duty holder is. Not always set in stone. It's not always going to be easy. Simple organisations, simple setups are going to be fine. Large organisations, it becomes very diluted. So what's an appointed person? Well, basically, if you remember, I mentioned earlier, many large organisations, the duty holder will sit at the top of the tree, such as COO, CEO, and legally they would be responsible under CAR. However, in reality, do they have the knowledge of asbestos? Are they competent? Do they know what needs to be done? They're probably too busy with the strategic side of the business, the financials of the organisation, and asbestos is not normally on their agenda. So to assist the duty holder in these types of organisations, they can and do a lot of times now appoint somebody to assist them in ensuring that requirements of the duty to manage are met, but they cannot pass on their legal responsibility. Their legal duty cannot be delegated. So they still become the duty holder, but someone else is doing the work for them. Now, the duty holder, the appointed person, I should say, was first born in 2010. When the document on screen was first published. Some of you will be familiar with this. It's Asbestos Survey Guide, HSG 264. The appointed person would be responsible for arranging surveys, managing the register, undertaking re-inspections, communicating the locations of asbestos, and generally undertaking their role to ensure that the requirements to manage asbestos are met. So now, on large organisations where you've got the COO sitting at the top, too busy, not on their agenda, someone else they'll delegate the work to, but not the legal responsibilities to what's known as an appointed person. They would need to be competent, suitably trained to undertake this, and more so given adequate resources to be able to manage the asbestos, such as time and such as financials and money. It's not cheap managing asbestos, arranging surveys, removal contractors, etc. So to meet the demands, it's a time-consuming role, but can be very, very expensive task as well. So whoever's in control, the duty holder must when they appoint somebody, must provide them with the adequate resources to be able to undertake their job. There should also be clear lines of responsibility between the duty holder and the appointed person. And they should be working together and should be in a position to be able to demonstrate compliance. So some of you may be listening to this are an appointed person. Some of you may be listening to this might be a duty holder. Some of you might not need an appointed person. It only tends to come into play more so in the larger organisations. So over the past 25 years, I already mentioned that I've been involved in several disagreements and some legal cases where I've been asked to determine who the duty holder is. And although we have been looking at this, there is no one-fits-all solution to determine this. Sometimes it can be very diluted. So many years ago, we were considering who the duty holder and the appointed person were in a very large organisation. With many people, it was getting diluted. It was trying to track down who that person was. And what was born out of that was what we termed as the reverse organogram. Now, I'm sure you're all familiar with what an organogram is. Generally, they're written from the top down. A reverse organogram starts from the bottom up. And this is what we use to sometimes advise clients as to where, obviously, their responsibilities lie. So remember, it's a reverse. So we'll start at the bottom and work upwards to the top of the tree, and we'll see where the responsibility lies. So on the screen, and this is not specific. This is just a model that can be adopted. So it's not an example of any organisation or whatever. It's just something that you can use to assist you in determining who the duty holder and appointed persons are if they are required. So the first step is what we need to do is we need to ascertain who is likely to be at risk. So starting at the bottom, you can see that there's internal contractors, external contractors, even the emergency services. Then we've got some employees, and then we've got some visitors. So what we're trying to do is we're trying to find how to get to the top. So we need to find a path from the bottom all the way to the top, such as the CEO, COO, MD, or the duty holder as defined. So we need to fill in the gaps and determine who is responsible for these groups of people. And we can separate those groups of people at the bottom. So starting from the left, we can see that we've got the contractors, the emergency service, etc. They would generally be reportable to someone involved in maintenance. So it could be an estates manager. Okay, I'm not, as I said, this is not specific. I'm just using general terms. So this individual is responsible for maintenance and contractors internally, externally. But you can see with the lines of authority there, they have no control over the employees or the visitors. Okay, so who's now going to look after them? Although the car regulations refers to maintenance, we've still got obligations to protect employees and also visitors. So there might be a business manager responsible for the operation day-to-day, business staff, visitors, etc. They may be responsible for the employees and visitors, but have no responsibility for the maintenance. So in this example, we've got two potential appointed persons, although probably the estates manager would probably do the majority of the works, arranging surveys, dealing with contractors, etc. But the business manager also needs to have an element of responsibility. A good example of this would be where an employee puts up pictures or shelves in their offices, potentially disturbing asbestos. They'll need clear instruction from their direct manager to ensure that they don't disturb asbestos. They're not going to go to the estates manager and ask, can I drill a hole in that wall? They may do, they may not. In my example, in my experience, they probably don't. So in this case, we've got two appointed persons, both report back to the duty holder. The duty holder ultimately is overall responsible. Now, as I said, this is not a one size fits all. This is something that if you analyse your business, analyse your site's arrangements, you can possibly start to route who has responsibility, but ultimately it's the bottom row that need protecting. So from the top, we've got to get to the bottom row, and anywhere in between, we have a number of different persons involved. You could have 25 sites around the UK. You might have to have an appointed person on every single site around the UK, but ultimately they'll be the top duty holder. So I hope that helps. And again, by all means, use something like this if you need to. So how can UKATA help? So UKATA this morning, actually, for those of you UKATA members, you would have seen an email from Craig Evans, the COO, who has literally just launched about 31 course syllabi under the UKATA banner. Me and Craig have been working on those with the board for quite some time now. But what we have regarding management and duty to manage, duty holders, appointed persons, we have four courses that have been developed over a number of years. So first one, duty to manage asbestos overview, manage asbestos in the housing sector, duty to manage asbestos the duty holder, and duty to manage asbestos appointed person. So quickly run through these because I see my time is flying by. So this is a one-day course aimed at those assisting duty holders and appointed persons, and will provide the learner with an overview and understanding of their duties, surveys, management plan, that kind of stuff. So that's just a one-day course, that one. The next one, similar to the previous one, but this is aimed at the housing sector. So of course, this will be looking at the common areas, non-domestic common areas of blocks of flats and within the housing sector. Very similar to the previous course, but rather than talking about commercial setups, chemical plants, etc., this would obviously be looking at the housing sector. This is a new one. This was just recently been developed. It was developed by UKATA as there was no specific training in industry aimed solely at duty holders. And with some of the things we looked at earlier around duty holders not understanding their legal responsibilities, this is now available to ensure duty holders are fully aware of their responsibilities. It's a little bit more in depth than the previous two. This is a 3-day course with an exam, I might add, ensuring that they understand their responsibilities and legal obligations. Being specifically aimed at duty holders, this course will satisfy the requirements to ensure that duty holders understand their responsibilities and hopefully become partway or competent in managing their asbestos. And finally, the last one, this was developed a number of years ago. This has been around for several years, probably about eight years now. And again, it was developed because there was no specific training for that appointed person, as stated in HSG 264. This has become a very popular course in industry, and it can be made bespoke to the organisation. There are a lot of management courses out there, and some of them are just set in stone. For example, if you work in a hospital trust or a housing association, the discussion on those off-the-shelf management courses will generally be around industrial or chemical plants, not necessarily your sector. So this particular course it can be bespoke around your sector. So if you're dealing with non-domestic common parts, let's say it can concentrate on that. There's no point in talking about a hospital trust or something like that. Likewise, if it's a school, there's no point in talking about hospitals. We'll concentrate on the school. So it can be more bespoke. Again, 3 days in duration with an exam. Will equip the appointed person with the skills and knowledge to appoint a surveyor, dissect the data, develop a register, an action plan, a communication plan, put them all together into a management plan. As part of this course, the delegates have to develop an asbestos management plan, which is the legislative requirement. So from that, then they can make an informed decision to remove, repair, encapsulate, and make informed decisions. And then the last one, just put this one in first thing this morning because it only came through. That is the current UKATA training portfolio. By all means, go onto the website and you can see all the various different courses. In essence, what's happened is we used to have the core syllabi and then we have addendums. All the addendums are now gone. So if you are a ground worker who requires asbestos awareness, there is a course syllabi for that. It's not an addendum anymore. If you're a ground worker doing non-licensed works, there is a course syllabi for ground workers doing non-licensed works. Okay, that's it from me.
Thank you very much, Graham. Thank you so much for all that information.
It's all right, I'll run over a bit, sorry.
It's okay. So as I mentioned earlier on, we are going to try and run through some questions. And if you have submitted one and we don't get time today, we will look at these after the session and we can email you back. And as I mentioned earlier on, you will get a copy of the presentation and the recording afterwards. So I know some of the questions that have popped up in the Q&A, I'm not sure if you've had a chance to look at them, Graham, yet, because you've been busy with your presentation. But some of the questions I believe have been covered, but if we could get some clarity on some of those, if that's okay.
That's fine, yeah.
Yeah, so I'll start from the bottom, if that's all right, with Mark Bartlett. He's asked, where does it in law or guidance that says a person, not an organisation?
Well, it's stated under the control, certainly Mark, for asbestos. It's stated in Regulation 4. It makes reference to a person all organisation. Because if you take schools, for example, where you've got a board of trustees, the board of trustees in theory would be the duty holder. If you've got a small organisation, like in my simplified example where I was the owner and the responsible, I am the person in essence. Now, legally, with regard to legal entities, shall we say, the employer is the organisation, but there's also always somebody that heads up that person. So under those types of examples, you're looking for a person normally, because if you put it down as an organisation, it's going to get diluted again. So we want to have one individual ideally in place. Hopefully that's answered your question, Mark.
Thank you. And again, we've got a question from Duncan McNichol. Would you be the duty holder if you lease your premises as the owner to a tenant? My understanding was that the duty applies to those in control of premises.
Again, that's a good example of what I mentioned earlier. If you are in control of the premises, but the key word we're looking for is maintenance. Now, if your tenants took over that commercial premises under health and safety legislation, Health and Safety at Work Act, they've got obligations under the various different sections there to look after their employees. If the landlord, however, was in control of the maintenance, then they would be responsible and they would be defined as the duty holder. So I think what you've got to do, Duncan, is you just need to look at your tenancy agreement. And remember also, I mentioned, Duncan, duty to cooperate. So the tenant in this case, if the landlord was the duty holder, the tenant has an obligation to assist and cooperate with the duty holder because they do have more control over the premises. But keyword is maintenance. But I agree, sometimes we should not always just concentrate on maintenance. We've got employees to look after as well, but the business would have an obligation, the Health and Safety at Work Act.
Thank you very much. I think this one was covered in slide 18. This is from Owen Davies. I manage healthcare properties, many of which have no single point of contact for a building. Who would be the duty holder in this situation?
Well, Owen, as far as I'm aware, and this was a number of years ago, but I'll apologise if I'm incorrect in this, but a number of years ago, NHS properties, this is NHS, I'm sure, I don't know if you are NHS or not. NHS, they put the chief executive as defined as the duty holder. Now, with regard to private healthcare, which I'm thinking you're probably referring to because you've not mentioned her trust, shall we say, with regards to the duty holder, it's going to go at the top of the tree. So run my organogram, reverse the organogram, and then if you want to do is put at the bottom of that organogram, put all your different properties, have somebody at the top who's overall control, and you'll probably find that there'll be a number of parties involved for each property that they're responsible for. But generally in those types of environments, as I said, nobody wants that responsibility because it is a lot of responsibility. So generally it will go to the top of the tree.
Thank you, Graham. One more from Mark Bartlett, which I think we've covered again towards the end. I know you were mentioning all the training courses available, and they are all available on our website. We've got the full portfolio on there. But Mark Bartlett's asked, what training do you consider a duty holder needs to hold to be competent to be a duty holder?
Well, they don't, in theory, need any training, Mark. And I'm going to cut off my nose here because obviously I'm a chair of UKATA. They don't need any training. Their competency can be defined by demonstration, by what they're actually doing. But you've highlighted something prior to obviously me just closing out there, is that there's no specific training course for duty holders. There is now. Mark, as I'm sure you've seen on the presentation, one of my last slides was referencing the duty to manage duty holder, which is a new course that's been put together by UKATA to ensure that duty holders understand their legal responsibilities, and that would go a very, very long way to ensuring competency of that duty holder.
Thank you very much. I've got a question here from Ian Blakely. Where were the changes to re-inspection times recorded for Regulation 4 properties?
Where were the changes to re-inspection times? Right, okay, this is an interesting one, Ian. I had this a number of years ago when I'd done one of these for IOSH, and I sort of set the cat amongst the pigeons. If you refer to L143, and this is how sad I probably come across, there's two paragraphs in L143. One is called paragraph 143, and there is called paragraph 144. If you read paragraph 143, it mentions 12 months, okay? But it doesn't mention 12 months re-inspection. It says the management plan needs to be reviewed every 12 months. What a lot of people do, Ian, I'm not saying you do this, is what a lot of people will do is read paragraph 143 and go, oh, 12 months, we're stuck at 12 months. Read paragraph 144. It goes on to say re-inspections are determined by a risk-based approach. So a good example, Ian, you've got a pad under the sink, nothing's going to happen to it. Why do you need to re-inspect every 12 months? You could set a procedure, a policy to do it every 18 months, 2 years, 3 years. So read those two paragraphs, Ian, and that will become apparent.
Thank you very much, Graham. I've got about 4 more questions. Is it okay to run through those,
Yeah,
the rest of them with you? Thank you very much. Okay, I'm going to go back to Duncan McNichol again, and he's asked, how do housing associations and local authorities work if there is a blend of domestic and non-domestic premises? I'm aware of the responsibilities for common areas. How does this work in practice?
Local authorities have a blend of domestic and non-domestic premises. Well, Duncan, the domestic premises starts at the front door. So as soon as you go through that front door, that becomes someone's home. That becomes a domestic premises. Therefore, there is no requirement to then manage the asbestos in that domestic property. I'm not saying it's right, but if you go to, there are authorities I know, not necessarily on the mainland, but I know they have a requirement for all domestic properties to be to have a duty holder in place, and the regulation for management comes into play. So the line really is the front door. As soon as that becomes somebody's home, that then becomes obviously a domestic premises where a person lives or resides, as would be the true definition. Obviously, with regards to regarding works being undertaken in those areas, if the work's been undertaken in a domestic, regulation 5 will still apply, identify hazards, identify asbestos, etc. So although there's no requirement to manage asbestos in domestic premises, there is still a lot of requirement to identify it for day-to-day maintenance, for refurbishment. And Duncan, I know obviously you're involved in asbestos and asbestos surveys, etc. So in that sense, refurbishment surveys would need to be undertaken. But the line is where a person lives or resides.
Thanks, Graham. I've got a question here from Wojciech Pratulski. If I'm principal contractor, automatically I become a duty holder as I have responsibilities under CDM 25 regulation. Is that correct? He's asking.
In essence, if you are controlling that site and it's it's going to be a very, very big project, then the asbestos still needs to be managed during that site. However, that would be that you'd pick that up under your construction phase plan. So because as part of the CDM requirements, you would have had a survey carried out, you'd identify where the asbestos is, and part of your principal contractor role would be to manage the asbestos for the works that you're undertaking. Now, obviously, again, I mentioned a document earlier, L127. It doesn't mention it in the new approved code of practice. There is a section there in about builders. It's not in the new one. So if I make reference to that under the old 2006 ACOP, it actually meant in there that it went on to say that a builder or contractor wouldn't be a duty holder under regulation 4. Now, it doesn't say that in the current ACOP, but I'm sure we could use that as a rough guide, as a rough example, but you would manage the asbestos based around your works under the construction phase plan.
Sorry, Graham, my question and answer box has just frozen on me. So
that's all right. I've only got two more, Victoria.
Thank you very much.
I've got a question here from Damien Rowland. Hi, Damien. I've seen you for a long time. Is there a training course that sits between appointed person and asbestos awareness, such as for those in charge of major planned works or for maintenance works? There is actually, Damien. It's referred to as the asbestos awareness for project managers. Perfect for your role in demolition, in the sense that it gives you an understanding of how to manage asbestos removal contractors and what's involved. It's a brief. It's not too heavy, but it gives you a better understanding in managing the asbestos on those demolition contractors. And then I've got one more last question. As principal contractor demolition, we're removing all asbestos before demo starts. If we are duty holder, do we need to develop an asbestos management plan? No, because you will have, if you're removing all the asbestos before the demo starts, you won't have a management survey. You will have a demolition survey, and that demolition survey will generally say all asbestos needs to be removed. Now, be mindful here, if it's going to take you a long period to remove that asbestos, let's say more than the 12 months that was mentioned earlier, or 18 months, then somebody's still got to manage that asbestos. So if it's a long drawn out removal process, then yes, you may have to develop an asbestos management plan. Victoria, that's all I've got question wise.
Okay.
So
I have got 3 more pop in now. Sorry, are you okay to take these, or do you want me to do it afterwards, Graham?
No, go on, we'll get them out of the way.
Thank you very much. So I've got Kerry Morgan. What level award are the UKATA duty holder or appointed person courses? Are they one-off courses, or do they require refreshers?
There are refreshers for them. And they're awarded by UKATA, and they'll obviously have CPD assigned with them. I don't know if I can mention something that was spoken about at a board meeting recently, but we are in the process. I'm going to say it. Craig will tell me off if I'm wrong. We are looking at getting these accredited courses. So we're working on that at the moment to get the appointed person, the duty holder, an accredited status, and that will be formal exams and everything else. But currently they just sit under the UKATA and the CPD requirements.
Thanks, Graham. I've got a message here from Callum. We have a maintenance supervisor running maintenance activities and an ops manager essentially overlooking the work is done. Would both these people be appointed persons and the ops director be the duty holder? We work within large industrial warehouses over multiple locations.
Yes, certainly. So you've got an operations director. Yes, so taking that Callum up to the top of the tree, someone with resources, somebody who can write the checks and say yay or nay, would probably be the duty holder in that case. Where you've got multiple locations, it's a good point. That operations director can't be in the same location, in different locations at the same time, I should say. So they will have to have somebody who's going to act on their behalf, and could well be an appointed person at each individual site to then actively manage the asbestos. But they don't have to be static. They could be floating between different sites.
Okay, Ian Blakely again with, if you don't mind, Graham, there's no legislation stating the age limit of a survey as far as I know. It talks about fit for purpose, or have any significant building changes have been made? So does that still apply?
No, you're quite correct. There is no age limit for a survey. Just speaking from experience, Ian, is that the previous document to HSG 264 was MDHS 100. It was a good document. It was okay. Quality of surveys back in the early 2000s. You've got to remember, this was a gravy train. There was all of a sudden all these buildings being surveyed, and there was hundreds and hundreds of people becoming asbestos surveyors. And I could tell you some horrific stories about it, but the time they had, there's not many accredited bodies out there either. So over the last, I would say, 10 years, surveying has become better. More organisations are becoming accredited and demonstrate that competency, and of course quality management systems as well. So you're right, there is no age limit to a survey. If it was done 20 years ago and it was done properly, there's no reason to have another survey. But we just got to cross-check some of these because the quality of surveys has changed over the years.
Thank you so much, Graham, and I appreciate you staying on to answer these
questions.
Problem. I do have 2 more. Is that okay? Or do you want me to do it? Thank you, Graham. 2. From Sarah, when an asbestos survey is completed but access cannot be surveyed due to restricted access, how is this treated when it becomes unrestricted? Does a survey need to have a follow-up inspection?
Yeah, be careful with this one, Sarah, because there's a potential here for creating a lot more work. If you read the HSG 264 document, especially if you're doing a management survey, and read box 4, I can't tell you what page, I think it's page 21, Box 4 details what a management survey should entail and where it should be accessed. Now, what we do tend to find is it's very easy for surveyors to say no access, no access, no access, no access. As soon as it becomes a no access area, you have to do a risk assessment on that area. You don't know what's in there, so you have to ascertain there is asbestos. You have to ascertain and assume it's worst case, so let's say spray coating. You have to assume the condition's really poor because you can't see it. In essence, by having a no accessed area, that area now becomes unaccessible. You are not allowed to access that area. So the only way you can get around that is you're going to have to call the surveyor back in and do a re-inspection in that area to prove, obviously, that there is no contamination or asbestos. So try to give the surveyor as much access as you possibly can. Make sure you've got key holders on site so that the survey can be full and frank. And if you do that, we can eliminate those no access areas, and that way you've got a proper survey undertaken.
Thank you very much, Graham. And Neil Thompson asked, can you repeat the course title for project managers?
Yes, certainly, no problem, Neil. It's asbestos awareness for project managers. It is a UKATA course, probably about 4 or 5 years old now. But again, as Damien mentioned earlier, it was highlighting that gap between the appointed person and the asbestos awareness for people who are dealing with, say, removal contractors on site. It gives you a better insight into what to expect by having asbestos removal works undertaken.
Thank you so much, Graham. And that concludes today's webinar. I'm really grateful for you staying on, well, for the whole thing, Graham. And thank you so much for everybody who's participated and engaged, asking questions. It does help build future webinars. This will be available afterwards. We'll be sending you a recording, and the recording of the webinar will also be available on our website. You can share it with colleagues, and keep an eye out for our future webinars. We've got another one coming up on the 8th of April. So please keep an eye out. We've got so many new things coming up, and it'd be great if you could join us again for a future session. Thank you very much.
Okay, thanks, Seth. Bye-bye.
Okay, goodbye. Thank you.
Bye-bye.